see in the two references I give there. And then in paragraph 67, we give various other references. Every time my Lord, my Lady, I say it's important because after 56 days, the jury would have been well aware of the seriousness of their task and that they must not talk to anyone and they must decide in accordance with the evidence.
But that's talking to somebody outside their number. What we're concerned with here is somebody within the...
I will come to what you might call the naughty juror in a moment. But I mean, obviously, it might be said he doesn't seem to have taken very much notice of it. I agree. I will deal with that. There is that point. But where I'm talking for the moment about I'm going to address the points of law, obviously. But as a matter of fact, the jury had well impressed, and certainly the 10, if I can put it that way, the 10 had well impressed in their minds the importance of deciding in accordance with the evidence. Of that, there can be no doubt. And throughout the trial, they are obviously very well aware of the enormous publicity this case is creating. They know they are doing a very serious job. It's not just a 1, 2, 3 day job, small case. This is the big case in Jamaica. It's on the news every night. Crowds outside the courtroom, crowds in the courtroom. They realize, so to speak, they are separate from the public. And that, in my submission, is an important point when bearing in mind whether the judge was entitled to trust the jury. I'll deal with about the miscreant. And in my submission, he was. He's given these directions. And they have, apart, of course, from the miscreant juror, there's no reason to doubt that the 10 have acted properly. My lords, my lady, the next point I want to emphasize, and I'll come to, if I may, the transcript, but the bribe was offered by the miscreant juror on behalf of, or rather in the interest of, all 5 defendants, including Shane Williams. Now, you can see why I emphasize that, because the jury obviously did not convict Shane Williams. Well, the 10 didn't. He was acquitted. And I'm going to come in a moment to the transcript, if I may. But while I'm on that point, the Shane Williams point, Chow gave evidence of a fight or the attack in which the 4 men apart from Shane Williams were involved. In other words, Shane Williams was not himself implicated by Chow in the actual killing. What he was implicated in was that it was said Chow gave evidence that Shane Williams, who he called Terence, was one of the men in the video talking about a killing. And that was the basis on which the case went to the jury. So there was evidence, the judge did allow evidence to go to the jury in relation to Shane Williams, but it wasn't what you might call the same evidence Chow gave against the other 4 men. If I can just give you the reference for Shane Williams's involvement, or rather Chow's evidence of Shane Williams' involvement, it's at E4011. And Shane Williams is one of the people identified in the video, which was said to be incriminating. That was the case against him. But I do submit it is important that is an indication the jury were not just saying to themselves, I see, a bribe has been offered on behalf of all of them, so they must all be guilty. The jury has distinguished between them.
Are you going to take us to the references to the 5, to the bribe being offered on behalf of all 5?
Oh, yes. Yes. Because I would like to go to, it's not a very long transcript, I would quite like to go to the transcript to see what actually happened in front of the judge. I'd like, if I may, to go to the facts first, and then I will deal with the issues of law which arise as a result of them. The transcript is at 5.1, begins, the relevant part, I think, is at 5.167. I should say actually 5164 is where the Chambers meeting begins, 2:20 p.m. on the last day of the trial, or rather, last day of the summing up. 2:20 p.m. court resumes, and the judge then reports that he's heard that a member of the jury has been offering a $500,000 bribe to do a particular thing. You see that about a third, halfway down. My lords, my ladies, just for information, the exchange rate at that point was in pounds, 180 Jamaican dollars to £1. So we're talking here about, I think, something in the region of £2,700. That's the total number.
So I think I'm on the wrong page. Which page are you on?
5164. Forgive me, my lord. I did say 5167, then I went back to 5164.
I'm now back. Thank you.
So that's the size of the bribe, if I can put it that way. I'm not saying that makes it any better, but obviously not. But on the other hand, it's not such a gigantic sum as to lead to the conclusion something that, well, there can only be an incredibly rich person who's offering it. So the judge says, well, I've heard about this bribe, apparently, and he explains how he's come to hear it. And then at 5167, or 5166, you'll see that the DPP has been called in, about a third of the way down the page. Now, she didn't present the case for the prosecution, but I'm told by her, she's in court at the moment, Miss Paola Llewellyn, that when this incident arose, the judge called for her if she was available to come along, as did indeed the deputy DPP. And so she turned up, because obviously this was a difficult incident to know what to deal with. So you see there at 5166, she's come along. And then you'll see what she suggests at the foot of the page, 5166, Judge, it's dependent on what your lordship decides. Clearly that's the issue. We'll have to go to another domain. That's between her themselves. I don't think there's any issue on that.
Right. Thank you. Doesn't actually tell us, does it?
You're right, my lord, but I have a feeling, I don't think it's in contention.
Thank you.
And before he says that he's going to call Madam Foreman, he says that he's going to summon that juror. And he's had instructions to the police.
Yes. In fact, he never does.
Yes.
But he does get the Madam Foreman along. And so she turns up. I'm now at 5167 at 2:43 p.m. Judge, you can see what the judge says, 5167, line 19. And if you can, it may be simpler, my lords, my lady, if you read on to 5173, rather than me picking out bits here and there, because there may be other things which I miss out, which you might want to
Sorry,
read.
to which page?
5173.
Thank you.
And then I'll make some comments on it. My lords, my lady, if you're ready, if I can just draw particular attention to the following points. First, at 5168, my learned friend is quite right, and he says, the contact was made with me today, so she finds out today. However, the contact has been made over a period of time with other jurors, and they confessed it to me. However, I cautioned them and told them that we are going solely on the evidence. I told them not to be swayed, that's the word, not to be swayed with what is being said, and they cannot be intimidated by what's been said either. So they're okay. And then she goes on to say how the bribing juror got in touch with her and seemed to be frightened of her at first, or frightened to do so at first. The second point is at 5170, at the top of the page, he called me out that's bribing juror. We were in the room. He said he needed to talk to me in the jury room. I asked him what he wanted to talk to me about. He said to me that he knows that I'm influential and people listen to me. I said it's not about listening to me. It's based on whether I pointed them to the facts of what we hear, not to be influenced by what is outside. He said to me, well, he needs me to do him a favour. And then dropping down, I asked him what was that about. He said that we should go to lunch. I said, no, I can't leave because I have things to do and I have somebody coming to me. Basically, he said, I should convince everybody to release, and then in answer to my Lady Simmon's point, the men at the bar, not at the bar. And then over the page, 5171, judge asked of the forewoman, you knew him before you came on the panel? No, I met him here. But when we met, that's when my suspicion of him grew. We started watching and observing his actions from there, because initially he was mad. They chose me as the foreman. He went to everyone and tried to ask them to make him the foreman instead. And basically goes on to say, it's a duty, and we don't, being the foreman doesn't mean I'm going to have tea in the judge's chambers, eat crackers and go for lunch. It's a duty. So that's what she's saying. So what she's saying essentially is he seems to have gotten to the head that he wants to be, as well, the big chief. He's disgruntled about this, and she just took no notice. But importantly, towards the end of 5171, but over time, he recognized that, okay, fine, before he started going to these persons and telling them that, listen, this is what we need to do. I would say you are listening to the evidence. He said, no, we just need to let go de men, again, them. So when we speak today, he said to me, that's what we need to do. And he says she says the conversation went on for 5 minutes, and she repeats the £500,000 figure. Then towards the end of 5172, he says, as Mr. Southey rightly pointed out, Madam Foreman, 11 of us. He spoke to 11 of us. That would probably suggest, therefore, the discharged juror. He spoke to 9 persons first. The thing is, nobody's listening to him. Because nobody's listening to him, he wants me to speak to them. I do emphasize that. So I'm not listening to him either. That's the reason why I got him on tape. But the trouble was, the tape wasn't particularly clear, so it never got played. And then you'll see at Madam Foreman leaves at 2:52 p.m. Now, I emphasize that because she leaves in advance, and the summing up doesn't resume, I think I'm right in saying, until about 3:20. So there's plenty of time for her to inform, because she's bound to inform the jurors of what has happened, that she's been to see the judge in chambers. And you'll see 5173, the DPP says to the judge, I wonder if you can allow each team to discuss for 5 minutes. I will wish to speak, and I'm sure my learned friends will wish to speak, perhaps 5 minutes. So again, the reason I emphasize this is there was time for the appellants to speak to, or rather the appellants' counsel, to speak to the appellants themselves. And then the DPP, towards the foot of 5173, recommends to the judge, just warn them again about their oath, just their oath. That is what she is suggesting. And then over the page, Mr. Finson, Tavares Finson, you'll see 5174, the DPP at the top, repeats, as far as the prosecution is concerned, we're prepared for the matter to proceed, just remind them of their oath. And then Mr. Palmer's counsel, we're of the view, don't see how you can proceed in these circumstances where you've got one person who is making an allegation that someone's going around offering the jurors money. She obviously has some tape, her role. So he seems to be objecting, not on the basis that, so to speak, there's a corrupt juror who is on their side, but rather he's rather concerned about what the forewoman is saying. But in any event, Ms. Llewellyn then says, the DPP says, in fact, it's the prosecution who is most disadvantaged by carrying on. And in my submission, that's obviously right, in principle. There's one person who obviously wants to let these people off. There is a risk that he is going to be persuading others, or has persuaded others. And then you'll see at the end, at 5175, the matter ends at 3:07 p.m. And what happened immediately after that is when the summing up resumes, the first thing the judge does, I think I'm right in saying, is remind the jury, if I can just dig up my reference, I hope this is right, 5149 at 3:22 p.m.
Just remind me, Mr. Rogers was representing who?
I think it's St John.
Right, so you've got Mr. Finson not exactly agreeing with the...
The Vincent's for Palmer.
Yes, I see. But you've got both Mr. Finson and then Mr. Rogers raising, on the face of it, objections.
Concerns, yeah. I would have to accept they're saying they're not very happy about this. And I think one of them says, I'm concerned about the overcompensation point. And maybe Mr. Rogers says there's a risk of overcompensation. That is to say, the jurors will swing too far in favour of the prosecution because of their knowledge of the bribery attempt. Can I just mention one point before I go to what the judge does? I should have made it before. It's not clear whether, and there was no investigation, whether or not the bribe was coming from the appellants themselves. And that's why I mentioned the figure of £2,700 equivalent. It may just be this particular person was, and don't forget we're talking about very famous people, he's a particular aficionado, we don't know, of Mr. Palmer's and Mr. Campbell's work. But in my submission, what the judge has done, subject of course to points of law, is in my submission, again, very difficult circumstances, but perfectly sensible. He's called in the relevant parties, and on the face of it, the party most affected by the problem, the prosecution, is saying, I'm prepared to carry on. And the reason, of course, for that is that this is day 56. In practice, it will be, or may well be, very difficult to get a retrial of this matter. Another 56 days, you're going to have to get Mr. Chow to come along again. I would hope that you could take judicial notice of the sheer difficulties, certainly in relation to some of these witnesses coming along again and arranging things. So on the face of it, it's the prosecution who's saying, I'm prepared to take this risk. And the first thing that then happens, going back to page 5149, is the judge reminding the jury at lines 3 to 13 of their duty.
He doesn't say there that they shouldn't hold anything against these appellants.
No, he doesn't. But my lady, I would submit it's obviously implicit. I mean, the context here is that the forewoman's been called over to see the judge to talk about the bribery, and she's been told to go back and tell the jurors to deal with the matter in accordance with their oath. And they, of course, will know about these allegations of bribery because it's said that the bribery has been offered to all of them.
So he can delegate his duty.
Well, my lady, my learned friends like that. But no, I'm not saying he can delegate his duty, but it's quite clear that he's taken a favourable impression of the forewoman, and it's quite a sensible way. He's not delegating, but he's saying to the forewoman, you tell them, as you have been already, you decide in accordance with your oath, and then he reminds them of exactly the same thing when you get to 5149. I agree he doesn't mention, and my lady, my lords, one can see why. He doesn't specifically mention, I gather someone has been bribing you. He's in a difficult position, whichever way he goes. And I submit it's a perfectly fair thing to say, I'm reminding you of your oath. It's an oath to decide in accordance with the evidence. And the jurors would have known that was their obligation.
Sorry, which page were you on when you're saying that he immediately tells the jury?
5149. The summing up resumes at 3:22 p.m. 5149. So the first thing he does is tell the jurors after the break, which everyone knows what it's going to be about. First thing he says, decide in accordance with your oath. In my submission, economy sometimes, just making the main point, is the best course. And this, in my submission, is a perfectly reasonable course for the judge to adopt, because everyone knows what he means by this. Can I just also emphasize that subsequently, at 5157, the judge repeats the direction he had already given, but importantly, he repeats at 5157, decide the case against each of these defendants separately. That's 5157, lines 10 to 18. And he then goes on at 5159. He gives the standard directions about reasonable doubt. At 5159, at the invitation, I think I'm right in saying, of the deputy DPP, who was back in the seat, so to speak, he gives good character directions at 5159. I think those good character directions applied to all the defendants, bar one. It may have been Mr. Jones, I'm not quite sure. Now, I mentioned the point about Shane Williams being acquitted. That, in my submission, is not an insignificant point. There are ECHR cases, which I don't have immediately to hand, but I'm sure I can find them in a minute, where problems have arisen, where the juries have reported to the judge that one of their number is making racist comments. And there was one case, I will come to it in a moment, where there were two defendants, and they were both Asian. And the report gets back to the judge. I'm very worried about this. This chap keeps on making racist comments to that effect. But the jury convict one, but acquit the other. The matter goes to Court of Appeal, who say, well, there's no doubt there was reason to suppose bias, but on the other hand, the judge gave directions to follow your oath, and the matter went to the ECHR, who took the same point. And they said, well, the judge did what was necessary, reminded them of their oath, and you can take into account the fact that the jury don't see. They do seem to be able to distinguish between the guilty and the innocent. My lords, my lady, if I can perhaps just have a moment, or if I can remind you of what that was in a moment, but I submit that is important. One cannot simply ignore the fact the jury, on the face of it, have performed their duty. They've put this evidence, they've looked at the evidence, and they've acquitted one person on whose behalf or in whose interest it was said this bribe was being offered. I think the name of the case is Gregory, but I don't have it. I don't have the reference to hand. So that's what I want to say about the facts. Then I come to the issues, if I may. I say there are two issues. The first is, was the judge obliged to discharge the jury? Did he have to? Did he have no real choice as a matter of law? The second issue is, if he was not obliged to discharge the jury, was the procedure he followed sufficient to ensure that all the defendants received a fair trial? Now, the first issue in my submission raises in turn two questions. The first is this: was the judge obliged to discharge the jury on the basis that there was good reason to suppose that one of them was biased in favour of the defendants, or indeed all the defendants, regardless of the prosecution's willingness to continue? In other words, just as a matter of law, was the position such that, look, you haven't got 11 impartial jurors here. We know you've got one bent one. He's bent in favour of the defence, but you have to discharge. And that's the first question as a matter of law. Notwithstanding the prosecution's waiver, if I can put it that way, of the point. That's question number one. The question number two is, was the judge obliged to discharge the jury on the basis that realistically the other 10 jurors, the non-bribing juror, the other 10 jurors would consciously or unconsciously be prejudiced by their knowledge of the offers of bribes, prejudiced against all the defendants, regardless of the directions that he had given, or indeed could give, to tell them to abide by their oath. That, in my submission, is a separate question.
Yeah, the way it's put in Putnam is a real risk that they might have become consciously or unconsciously prejudiced.
Real risk they might have become. That's why, forgive me, my lord, I was trying to go by the Putnam test, consciously or unconsciously. Is that something which is going to be in the back of their minds, come what may? Now, on the first question, namely, you've got one rotten apple here, so that's it. We say that can't be right. And we have in our written case drawn attention to the case of Brown, which is in the electronic bundle at 6329, paragraph 31, where not identical thing happened, but the problem arose, what is a judge to do? Or rather, the point was made that the defendants cannot derail trials just by making offers of bribes to juries and so forth. It's not on all fours, but I submit it is important all the same. So it's 6329. And it's paragraph 31. We fully understand any judge's reluctance to discharge a jury in circumstances to which a defendant bore material responsibility, although there are no doubt gradations of responsibility, starting with deliberate misconduct by a defendant aimed at achieving a discharge in circumstances where a trial is going badly, or at achieving a favourable verdict and ranging downwards in seriousness from those situations. Counsel for the appellant thus rightly, in our view, accepted before us that it cannot be open to a defendant to obtain the discharge of a jury by deliberately creating some ground of aggravation or discord between him and the jury, whether inside or outside court. But in order for a judge to rely on the appellant's responsibility for events occurring as a ground for not discharging a jury, the circumstances giving rise to such responsibility must, it seems to us, either be agreed or ascertained by the judge to exist. They cannot be assumed simply as a prima facie case. Now, that's not on all fours, but I submit the basic point is this. It's not open to either a defendant himself or indeed a juror acting, if you like, without instructions from the defendant, but nonetheless in the defendant's interest to derail a trial. And I submit that's an important point, and I submit it also goes to the whole jury system. And it will bring the jury system into disrepute in a case such as this. If the position is really this, there are 10 innocent jurors who have performed their duty, assume for the moment, who have performed their duty without any shred of bias. It would bring the system into disrepute if the verdict is nonetheless to be set aside because of the one bad juror who was not obeying his duty. I submit that would be, one can understand what you might call the purest version of that. One can understand, of course, the notion that a jury has collective responsibility. But in my submission, that would be would strike, I submit, what you might call the man in the street, the sensible man in the street, as a remarkable result.
But the normal scenario would be that, of course, you get rid of that juror.
I agree. The difficulty here...
I mean, you wouldn't say, well, you can carry on with that juror.
But I think, my lords, I'm bound to accept that we don't know, of course, but obviously what concerned the judge is, I don't think I took you specifically to it, but he does at one point say, what am I going to do? Either I let the juror out, in which case the case can't continue, or it carries on. I accept what your lordship says, but my lord, again...
But what I'm saying is the quote from paragraph 31 leads us to the obvious result that, of course, a juror who's refusing to obey directions has to go.
He has to go. Well,
that doesn't then follow that, oh, you can leave him on.
No. Subject to one point, what I call the waiver point. And the prosecution here, it is, as they pointed out, they're the losers in this. And they are prepared.
How can you be sure? You just don't know. You don't know.
Well, my lady, funny enough, we do know in one sense because it was a 10-1 verdict, and we know from evidence acquired afterwards that you know who was the one. I don't think there's any doubt about that. And that was a matter of witness evidence obtained by, funny enough, the defence afterwards.
Yes, but if there's a... Well, I think the point that her ladyship is making is that one doesn't know how people may react to an attempt to bribe them. If the jurors thought that an attempt was being made to bribe them on behalf of the defendants, then that might have, who knows, it could have inclined them to dig their heels in and prejudice them against the defendant.
My lord, I agree. That, of course, is the second question. I'm just on the first question for the moment. Can I, namely, there was just a rotten juror Does that of itself mean the verdict cannot stand? And can I give you an example where I submit it is not of itself a sufficient reason? Supposing what happens is this. A jury comes in with, let's say, a 10-1 verdict. The one has been bribed, but the one has not revealed that to anyone else. It all comes out after the trial. Can the defendant come along after and say, oh, dear, 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 there was a rotten juror on that, he didn't tell anyone about it, but nonetheless the verdict must be set aside because there was just one, as well, there was one person who wasn't performing his duty, qua juror. My submission would be that would receive short shrift from the appellate court. It would say, well, the rotten juror didn't speak to anyone, he didn't obey his duty, he did come in with a not guilty verdict because he'd been bribed, but on the other hand, that made no difference whatsoever to the 10 who did come in with a guilty verdict. We know it didn't, because he didn't even mention it. Now, in those circumstances, I submit the verdict would stand. And I simply give that as an example as to why what you might call the pure point, there have to be 11 good jurors, even when there's a 10-1 verdict and the 10 are good. There have to be 11, and the whole thing falls to pieces. Cannot be right. And I submit that, in the example I've given, that would give rise to very considerable public concern.
But the trouble is, we don't know.
I've got to add that.
We're not supposed to know.
Well, I know we're not.
Who's saying what in the jury room? So you can never. So the hypothetical you've given can never arise in reality.
Well, my lord, I hesitate to disagree, but I would submit it could arise, and indeed, in this case, we do know precisely what happened. Yeah. I mean, supposing Livingston came, for whatever reason, supposing he had not mentioned any of this to the jurors, but afterwards it came out that he had actually received bribes and was convicted. But let's just say, or he had received bribes from one of the defendants. So it's not on all fours, but I'm simply at the moment on the point, do there have to be 11 good jurors, full stop? And if there's one bad juror, the whole thing falls away. I submit that's not right. The other question is the different question entirely, namely, what about the juror, the 10 good jurors, saying to themselves, well, you know, obviously, they're all bent, these people, and so I'm going to hold, this is a little bit of prejudicial information which they're holding against the four appellants. That's the question. Now, my respectful submission on that is, as well the second part of the question, is this. The question is, was the judge bound to assume, in all the circumstances, that whatever directions he had given, or could give, was he bound to assume that the taint, if I can put it that way, of the bribing juror was never going to leave the minds of the 10 good jurors, such that, maybe even unconsciously, they would hold this against the accused?
But isn't that the wrong way round? Doesn't he have to be sure that there isn't that risk, rather than where you've put it?
Well,
he has to be sure that there won't be, that justice will be done, yes, rather than the other way around.
My lady?
I'm trying to...
Yes, I'm bound to accept that. I maybe there are too many double negatives in what I was saying. I accept he has to satisfy himself that he is in a position, given what he's already said and will say, to ensure that there will be a fair trial for the other appellants. Yeah. That's the question. And in my submission, it's a question of fact to an extent, but on the facts, I submit he was entitled to come to the conclusion that the 10 jurors, with proper directions, would not take into account the fact that one of them had been offering bribes. And that, in my submission, was obviously a matter for the trial judge himself to assess, and that's how he assessed it. And my lords, my lady, I also rely on the fact that the Court of Appeal upheld the judge's judgment on this point. So what you would be effectively doing is saying to the, as were the local courts, they were wrong to hold that justice, there could be a fair trial, notwithstanding.
But the Court of Appeal appears to have been comforted by the fact that there was nothing to be gained by questioning or looking into the matter any further. at best a denial of bribery, and a great deal that would have been lost, the possibility of having to discharge the whole jury. Was that the right approach?
Well, my lady, I think one has to bear in mind what was being put to the Court of Appeal. I think from recollection, what was being said to the Court of Appeal, and is not so much being said now, is that the judge should have carried out an inquiry. He should have made more inquiries. My answer to that is that if the judge was satisfied that a direction would put the matter right, then he was entitled to take that course. I agree. I agree. The question is, could he rationally be satisfied? You might say if he couldn't rationally be satisfied, well, that's that. But in my submission, he could be, for the reasons I've already, in a sense, gone through right at the beginning. He has reminded the jury of the seriousness of their role and the importance of deciding in accordance with the evidence. He's told them again and again, you are the judges. You are not to speak to anyone. They are well aware of their special position. And I submit it's quite often the case that prejudicial information comes out in the course of the trial, which gets in front of the jury. And as long as a judge's direction, I'll come on to the direction in a moment, as long as a judge judge's direction is sufficient to ensure that the jury will decide in accordance with the evidence and not in accordance with the unfair prejudicial material, then he's entitled to take that course. And my lords, my lady, obviously one can well understand, of course, the concern in this case. Of course, that it might be said, well, who could forget? But my lady, my lords, I submit it's not that difficult. Jurors have to be trusted to act in accordance with their oath. I want to take you to a case about that. It's a cardinal principle that jurors do act in accordance with their oath, and they act only in accordance with the evidence. And if I may, can I take you back to the case of Bonnet, where Lord Hope makes this point, and he refers to other cases of high authority, which say the cardinal principle of jury trial is that jurors act in accordance with their oath. They're not nincompoops.
Can I just ask you, in the context of your submissions, do you see any role for the Porter and McGill test?
It's fair to say that where I'm putting it is that the question is whether there was a fair trial or not. And in my submission, if one could be satisfied that there was a fair trial, that is that. I mean, in one sense, I accept that what I'm saying is that if the court is satisfied there was no risk of in one sense, Porter and McGill is to do with a real risk of possibility that the tribunal is biased. But it's not the appearance so much, but there is a risk of possible bias. And to that extent, I accept Porter and McGill is right, because in my submission, what the judge did was to remove any risk of possible bias. It's not quite the same way as the Putnam test, but it comes to much the same. But appearance of bias per se, I submit, is not the relevant test. The question is, was there a real risk or possibility of bias?
And you say he removed that by the direction he gave at 3:22?
And also by what he'd been telling them before. It's the whole thing has to be looked at. It's often said in the cases that the judge is entitled to look at the judge, in making these sorts of decisions, will bear in mind his view of the jury, so far as he can tell, over the course of the hearing. And in my submission, he was entitled to take into account also what the forewoman had said to him. And I do submit, if one asks, and looking at everything, if one looks at A, the verdict, B, the letting off of Shane Williams, and C, the evidence, which I'll come to later if I may, which is simply overwhelming, one asks, what unconscious bias, so to speak, added to all the evidence which was there anyway? How could it have done? And that is the point about the strength of the case. One can see where the evidence is equivocal and so forth. One might say, well, that's rather harder to tell. But if it's 2 and 2 equals 4, well, there is in my submission a basis for saying the risk of the possibility of bias it has been removed, was not likely to have affected the jury's verdict, or won't have affected the jury's verdict. Can I just take you to the Bonnet and Taylor case? Because it is important at this point. To what extent can you trust the jury to act properly and in accordance with their oath? And we looked at one passage already. It's at 6291. Paragraph, I think I'm right in saying, 6290, one can begin at, paragraph 24. There was, however, another course that the judge could have taken, and did take in this case. That's say, not making further inquiries about the juror. At the outset of his summing up, he gave the usual direction to the jury. It was for them to decide what evidence to accept and what to reject. He then gave this direction: decide this case on the evidence and only on the evidence. Do not be influenced by anything you might have been told by anyone, whether by some fellow member of the jury that sat or are sitting with you about some prior knowledge or feeling or view. That is unimportant. And if you act upon that, justice will have miscarried, because that's not the evidence. I hope that I'm making myself absolutely clear that it's the evidence and only the evidence in this case that you have heard that you're entitled to act upon and determine. Having looked at the evidence, examined it, weighed it, determined what facts are, and ultimately what your verdict is after applying the law. And I will give you to the facts that you find proved. Now, I agree that's a stronger warning, but nonetheless, it's to the same effect. Then, the important passage in paragraph 25. The assumption must be that the jury understood and followed the direction that they were given. See, a judgment of my own, as it were. In the Supreme Court of Canada, in Corbett, Chief Justice Dixon said that the experience of trial judges is that juries perform their duty according to the law. In the High Court of Australia, in Denham, Mason CJ and Toohey J said that the law proceeds on the footing that the jury, acting in accordance with the instructions given to them by the trial judge, will render a true verdict in accordance with the evidence. To conclude otherwise would be to underrate the integrity of the system of trial by jury and the effect on the jury of the instructions by the trial judge. In the Irish High Court case at Z, Hamilton P. expressed confidence in juries to follow the directions given to them by the trial judge. The direction which the judge gave in this case was clear, understandable, to the point. The board is satisfied that it is sufficient to deal with any risk that the juror who is excused might have said something that the jury ought not to have been told. Now, of course, my lord, everything turns, in one sense, on the facts of a particular case. But I do submit it as a fundamental principle that you trust the jury to act in accordance with their oath. And it is implicit both in the judge's decision to leave this matter to the jury and in the Court of Appeal's decision that they were satisfied with their knowledge, if I can put it this way, of how jurors work, that they would have done.
And does it matter that, I mean, inevitably you're focusing on the 10 because he didn't trust the 11th. He had the police ready. He said he had the police ready.
I accept that. That goes back to my answer to the first part. I accept he probably doesn't.
Does it matter for these purposes that effectively he's trusting a jury of 10
Yes.
And 10's not a jury within the Jury Act in Jamaica, is it?
One then gets into what I call a rather metaphysical argument about what is a jury. Clearly, it's 11 people who walk into court. About that, I go back to what I call the first question. Is it really the case that there is no jury if it turns out afterwards that one of them had taken a bribe and was going to acquit come what may?
That's if it turns out afterwards.
Yes.
What if you know going in?
If you know going in, I submit the same follows.
The same.
The judge is entitled to say this: a 10-1 verdict is a good verdict. It's authorised by law. I have good reason. I'm just, as it were, expressing in words what no doubt the judge would be thinking. I have good reason to trust the 10. They will follow my directions. That is good enough to satisfy the requirements of the statute, that there be a jury who decides this. Because there are 11 altogether, and if there are 11 altogether and one of them still takes no notice of what I say, well, so be it. But my Lord Audrey put the point at the beginning. It's quite a short point, but quite an important point. But I do submit that the crossover between these two questions does arise, but I suppose it's very important to keep them separate. Because if I'm right in saying that a verdict by 11 men, or 11 men and women, one of whom is bent, is a good verdict at the time, then it's a good verdict. If, on the other hand, it's clear that there's a real risk that the 10 might have been influenced by the one, then I accept. That might be a basis for setting aside the verdict.
Just starting with the one, you say that the judge can choose to leave somebody on the jury, notwithstanding that he knows this person is corrupt. Presumably, it's the same if he knows that the juror is mentally ill or communicating with the deceased via a Ouija board or has been looking up the internet. It's the same, is it?
No. No, my lords, it wouldn't be the same. If I may, no. The important point here is the prosecution knows the problem, and in the passage I took you to, the prosecution says, we're the ones taking the risk.
Well, but they can't waive the public interest in the administration of justice. It's not a matter...
Well, the difficulty, my lords, if this had happened on day one, it would be a very different position, obviously.
You're really just postponing the question. So, on your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the Lordship is putting to be saying, well, in those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then, boom, one thing comes out. Now, in my submission, the question is simply this. I mean, it does get to this point. If I'm right in saying that a verdict of a 10-1 verdict of 10 good people and one bent person is a good verdict as a matter of law, then the judge is entitled, and the prosecution is entitled to say, well, I dare say that person won't obey his oath, but I'm satisfied the other 10 will.
But that's assuming there's going to be a conviction. And the jury has, if it's going to acquit, is going to have to do it by, is it an 11-person jury is going to have to do it by a 10-1 majority. And how does the judge know? Well, it's likely that there will be 9 good people and true and 1 crook in the 10. It's an acquittal.
Well, my lord, if in my submission, the judge, the fundamental right is to a fair trial for the defendants. If the prosecution, and in one sense, this whole case comes down to one point. Can the prosecution say, I know there is this one person who seems to be offering bribes, we probably can't trust him, but I'm prepared to carry on and take that risk. Is it open to the prosecution to do that? That is the question. That's what the prosecution did. And in my submission, the answer is yes. There's no authority, if I may, with great respect say, that says, no, the prosecution cannot do that, because that would deprive the accused of an unfair trial. I also make this point. The question is not, so to speak, at the very moment this all takes place, but looked at broadly, looking at that verdict. Have the defendants received a fair trial? If one is satisfied, the 10 were not influenced. I agree, obviously, that's the separate question. But assume for the moment that the 10 applied with their oath, they acted properly. Is it really to be said that that was a bad verdict and the defendants must be acquitted or the appeal must be allowed? I submit no. That, I do firmly say that would bring justice into disrepute. 10 people have done their duty, one person has messed it all up, but the verdict is a good verdict at 10-1. Why does it matter if the one has brought disaster? That brings the jury system into disrepute. My learned friends, of course, rightly say that in England we don't have that problem. But this is a common law point. And the question is, what is the common law in this situation? And that's why I urge upon your lordships the point that I'm making. I fully accept you've got the separate point about who knows what was going on in the back of the jurors' minds. That's a different point. But my point is just on this, what you might call the degree to which there have to be 11 people on the jury. The fact is there were 11 people on the jury. That is my short answer to this. One of whom, at the time, there was good reason to suppose wouldn't act properly, and who we now know didn't act properly. I submit that's not a conclusive answer. And
Can I just take you to, where we got to, I think, which was paragraph 25 of the Bonnet-Taylor decision, page
Yes.
6291.
Yes, thank you.
Lord Hope very clearly says that the direction which the judge gave in this case was clear, understandable, and to the point. And we look either earlier at what was being put forward as the defence, as the direction.
Yes.
Don't allow anyone that you sat or sitting with about some prior knowledge or feeling or view, that's unimportant. In other words, he's directed the jury to the specific problem. Now, just to say you've got to carry on with your oath seems to me non-specific. It is not to the point. It doesn't make clear to the jury precisely what the judge is wanting them to do.
In my submission in this context, it does, because they will all know there's been this half-hour break in the summing up. While form has been called away, she would have told them, because the judge says, tell the others. She would have told them what's happened. And my lord, I fully accept, of course, one might say the direction could be more forceful. I accept that. But the question is, was it sufficient to ensure the fairness of the trial, given everything else which I've mentioned? And in my submission, it was.
But all I'm saying to you, putting to you, is that what was said by Lord Hope hardly supports your case, because this was not a specific direction.
Well, my lord, not express. I don't want to, as it were, quibble. I accept it was not specific, and of course, it would have been better were it this specific. But the question is, was the direction given by the judge taken together with everything he had already said, and the juror's sense of responsibility, was it sufficient? But of course, this is a different point. My submission is it was, in one sense. I take your lordship's point. It's not specific in the way this was, but in my submission, it was sufficient.
Could be. I'm not sure that it. I think you probably have dealt with this point, but it strikes me. But when you say this is a question of common law, I don't think it's purely common law, because we do have the statutory provision.
Yes.
It's on page 6803.
Yes.
Which tells us that 12 jurors form the array in a case of murder, and then says in subsection 3, where in the course of a trial any member of the jury dies, or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as the number of its members, so it's a proviso, so long as the number of its members are not reduced by more than one, be considered as remaining properly constituted. Now, it might be said that the judge, as it were, can't sidestep that provision by failing to discharge somebody where there was indeed sufficient cause to discharge them. If he discovered, for example, that the person, the person had been bribed, or was the defendant's brother-in-law, or whatever you like.
Well, in my submission, that wouldn't be the correct construction of this. In one sense, you have my point. As long as there are.
I mean, you're saying it's just a question of counting the number of live bodies on the jury, and
that's all it's saying.
Yeah.
Well, my learned friends, my submission, that's what it's saying.
Yeah.
And my lord, after all, one doesn't know. I mean, at the time the judge gives his direction and decides what to do, he might be hoping against hope, so to speak, that the miscreant juror will actually just see sense. Mm-hmm. But it doesn't follow, in my submission, from this act that the judge is bound to get rid of that juror. That's the question. But I agree, if he's bound to get rid of that juror, he's bound to bring the case to an end for that very reason. And this is why it is a short point, but in my submission, a difficult and interesting point. I haven't addressed you on the proviso and things like that, but I'm conscious of the time. But I wouldn't mind showing you some of the evidence. I mean, it is, because I do connect it to my point. Well, there was no need for any, if I can put it this way. Anyone looking at the evidence would say, I couldn't care less about these bribes, so what? I've seen it with my own two eyes, type of thing. Forget the bribe.
Yes.
But I'm conscious, my lord, I'm preying on your time. I don't know how you want to proceed. I see what the time is now.
Well, obviously you have more time tomorrow. We perhaps, speaking for myself, yes. The point you've made about how you could find out after the event that a juror was corrupt. And the question then is if the other jurors had voted 10-1 to convict, completely ignorant of the fact that would the verdict nevertheless be vitiated, and it would have to. And I think if it were, it would be on the basis that we've been discussing, that there is, as it were, a non-quorate.
Non-quorate point, really, yeah.
Which suggests it may suggest that the point we made earlier, the point I made earlier about based on. Seraphim may not be quite as obvious when you have 11 judges, as it were, as it is where you've got one judge.
As in that case.
Well, shall we leave it there, Philip?
I'm so sorry. Yes. The case that you mentioned in Strasbourg about the racist members of the jury, do you have the reference?
Mr. Turnbull has the reference. It's Gregory v. UK, page 7914. And I have a feeling there are two other cases which similar issues arose. Yeah. I cannot quite remember. If you give me one, sorry? Sander's one of them. Is there? And there was another one too.
There's a Russian case, which is not exactly on point Tinkov.
Oh yes, there's the Russian case, that's right. Yeah. 8373. At 373. 8373. Thank you.
Very well.
Sander is
sorry.
7960. Thank you.
Well, I think we may have reached a convenient point to adjourn for the day. We'll consider where we are in relation to the JS2 point ourselves, and we'll look forward to hearing the remainder of your submissions tomorrow, Mr. Knox.
I would like to.